Okay, let's say that you are out one day on your motorcycle and somebody crashes into you, and it's accepted that it's their fault and they cause you very, very serious injuries. And when it goes to court, the judge decides that you should be entitled to £1.2 million in compensation. However, the judge also finds that you exaggerated your claim and you pretended your injuries were even worse than they were. So how much should you actually get? Well, the courts have confirmed the answer is absolutely nothing. Zero zilch. So why is this? Before I forget, do the like and subscribe thing. Yes, sorry, if you are about to find this vaguely useful or vaguely interesting. Please just do all that clicking now. This is what happened. So some guy's out on his motorbike, somebody crashes into him, and they admit liability. The insurers, on behalf of the driver, say, okay, fair enough, it's our driver's problem. And they actually agree and say, you're going to get a lot of money for this, we'll give you £150,000 up front. But then they put the claim in and they say, I want 4 million. And it's ruined my base jumping career, I can only walk like 10 yards now, it's really, really, really bad. But they get a bit sceptical about this and go, well, we're not really sure about this. And they actually write and say, look, if you over-exaggerate this claim, we will make a big fuss about this at court. But it goes to trial, and of course, he says, oh, my injuries are X, Y, and Z. And most of them aren't disputed. The experts come along and go, yeah, this is a really serious accident. And they give a huge list of all the bones they had to repair, all the organs they had to stitch together, all the bits they had to screw in there, bone grafts and all sorts of stuff. But they also go, here's a Facebook post where he's actually just done a base jump. He's done a parachute jump. Now he says, oh, no, that wasn't me. My friend did the parachute jump, but then he was a bit tired, so I agreed to carry his parachute for him. And that's why it might look to the untrained observer that I'm wearing a parachute. The judge decides, no, you've over-exaggerated this. But there's a piece of legislation that came in a little while ago, after all this sort of cash for crash type stuff, or crash for cash, whichever way around it is, or trip and slip, with people basically exaggerating, claims and putting in false claims. So the government passed a piece of legislation, and it said that where a claim is found to be of an element of fundamental dishonesty, the court must do the following. It must first of all say you get nothing, including the bits that otherwise you would have been legitimately entitled to. And just to rub it in, the court also has to say, this is what you would have won. It's all very bullseye. So at the hearing, they said, well, hang on a second, this is really, really unfair, because, it's all accepted he's entitled to at least, £1.2 million. So the legislation has a proviso that says the court must do this, except where that would cause a substantial injustice. So what's the definition of substantial injustice? And the argument that the defendants put in was, well, look, loads of people get injured every day, but there's not a solvent tortfeasor, to use the old language, that they can go after. So even though it's somebody else's fault, they suffer an injury and they don't exaggerate their claim, they just don't recover anything, they just have to go on benefits. So if innocent people are just left, uncompensated, why should somebody who has been fundamentally dishonest? And the claimants, they said, well, no, look, we need to look at what was actually said when this legislation was passed. And this gives me an opportunity to talk about something called the rule in pepper and heart. Because generally speaking, there's this thing that English judges do not make law. They merely interpret the law that Parliament passes. Now, when it comes to interpreting that, can they actually look at what Parliament said? What was said, during the passage of the bill and, before it became legislation. And there used to be a rule saying, no, you can't do that. And the rationale for that was things like, well, let's say somebody's passing a piece of legislation and then just before people say, aye or no, somebody just says, can the minister confirm that what this actually means is X, Y, and Z? And the minister says, yeah, of course it does. And that's not been discussed or voted on or anything like that. Then the argument is if you go back, somebody could just throw something out there as a comment. and it's actually fundamentally not what they've spent, months arguing about, because the passage for a bill to become legislation is quite complex. They put out the bill at first saying this is what we suggest, it gets a first reading in the House, people propose amendments, it gets a second reading, it goes off to the House of Lords, they check it all over, it goes back to the House of Commons, and eventually when everybody's agreed and they've voted on all the amendments, they pass that and it goes off for royal assent, and then it's a statute, it's legislation, and once the king has given his assent, it becomes law. Although sometimes it can be the king gives assent for this to become law when the relevant minister says, okay, it's now active. There used to be a little book called Is It in Force? And you got daily updates, so you'd have to look through and see if the relevant law had actually been enacted. I mean, now you can just go online and just check. I had this once though in a court martial. There was an argument as to whether a piece of legislation applied. And the judge said, I'll hear skeleton arguments in the morning. So we were basically just, I'll hear arguments in the morning, get your skeleton arguments ready. So me and the poor old prosecutor, we were both actually stopping in the same pub in Amesbury, because this was when I used to do a lot of work at Bulford Camp. And they were really nice. They used to list things at Bulford Camp for me because they knew I liked wandering around Salisbury Plain. This was in the old days when court martial was like being at the bar in the 30s. They'd send cars for you and pay for your wine in the evening and stuff. None of that now. But of course we duly pitched up in the morning and the judge said, gentlemen, have you seen this morning's Times? And there was literally a law report that totally just clarified the position. So I'm glad I stayed up all night for that. This law had been passed. And what the judge said is, well, I will have a look at it. I'm not saying that I should be looking at it, but I'll see what it says. And at the time, this question was raised where they said, well, surely substantial injustice means that, you don't get what you're entitled to. And there was actually an opposition amendment saying that the penalty should be, you just lose the exaggerated bit, not everything. But that amendment was not passed. So the judge said, it's fairly clear that the intention of Parliament, as they call it, was that, this is a really draconian punishment to penalise people who exaggerate claims. So regardless of the fact that this person had a very, very good claim, we're not giving them anything, including what they would otherwise have been entitled to. And also, they ordered that he had to pay the £150,000 that had already been paid. He has to pay that back, even though he's all spent it on sort of, disability aids and things like that. So this is a really harsh one. So there you go, a salutary warning to anybody thinking of exaggerating a claim. I mean, don't get me wrong, obviously there's a subjective element when people go, I'm really suffering, I'm really hurting. And courts will not penalise you just for sort of, putting the best spin on your injuries. But in this particular case, they said you've outright lied because, you're saying you can only walk with crutches, you need a motorised scooter, and all your old hobbies like base jumping you can no longer enjoy, but it's fairly clear you have been base jumping, and they had all the surveillance and stuff. But this is also a warning about not putting things on social media. I mean, if you bring a civil claim now, especially against an insurer, they quite often put private investigators just to film you walking around town and film you going to the gym. But now you do that job for them because you just stick everything on Instagram or Facebook or Twitter, and they will just look for that themselves, but also they can ask for it to be disclosed. Say you think it's private. You can say, actually, I want you to give us screenshots of all your recent Facebook posts to all your friends, and we need to have a sniff around them because we think you are not being entirely honest. So like I say, the test is fundamental dishonesty. It's not just like exaggerating a little bit. But there you go. And, what's therefore counts as substantial injustice if this doesn't. And the only example anybody's come up with is saying, well, what if it was somebody acting on behalf of a minor? Because children can't bring their own claim. So let's say a child was injured and it was their litigation friend, the person who runs the case on their behalf. What if they exaggerated? They said, well, maybe in that particular case, they wouldn't hold it against the child. But that's the only example we can think of. I mean, I quite like it when they actually do give courts a discretion. You get this in sentencing a lot. You get, like with, possession of a firearms is a mandatory minimum 5-year sentence unless exceptional circumstances apply. So that does give a judge, an opportunity to not be painted into a corner if some completely unexpected scenario crops up. But in this particular case, they said, no, this is exactly the scenario we predicted. People exaggerating claims, so he's getting note. So there you go. As always, hope you found that vaguely useful, vaguely interesting, vaguely accurate. I've already done the like and subscribe thing, so there you go. Where I'm at today, I'm just back up at Pentire again. I'm meeting a friend over at the Lewinick shortly. In fact, that thing pinging is probably him going, where are you? So I'll pack up and I'll head over there.